Senator Waters.
Thanks, Mr President. My question is to the Attorney-General, Senator Brandis QC. I refer to the successful court action by Mackay Conservation Group to suspend federal approval for Adani's Carmichael mega coal mine in the Galilee Basin, which you've called vigilante litigation. Attorney, over the weekend you mooted rewriting our national environmental laws to stop ordinary Australians from enforcing the law when governments and mining companies ignore it. Why are you so eager to put coal mining companies above the law? Could it be their enormous donations to your party?
The Attorney-General, Senator Brandis.
Well, Senator Waters, I'm not aware that Adani donates any money to the Liberal Party, as a matter of fact, but Senator Waters, this government is a strong supporter of coal mining. Let there be no mistake about that. And you, as a Queensland senator, should be ashamed of yourself for being party to attempts to destroy Queensland's most prosperous industry, the great engine of job creation in our state. Now, the Carmichael mine being promoted by Adani was a $16.5 billion project, a $16.5 billion project, which in the initial stages would have created 2,600 jobs, and across the life of the project was estimated to be worth 10,000 jobs. And the fact, Senator Waters, that you are sitting there smiling, gloating at the fact that 10,000 jobs have been destroyed, 10,000 jobs and livelihoods have been lost by vigilante environmental groups determined to game the system in order to stop this important development, this important contribution to Queensland's economy, is a disgrace. Yeah, well, Senator McDonald, Senator Waters is a Queensland senator, but you wouldn't know it. Now, Senator Waters, in my view, the standing provisions in the Environment Protection and Biodiversity Conservation Act are way too widely drawn, far too widely drawn. They are a red carpet for people who want to stop development, to game the system by bringing vigilante litigation, and therefore that is why the government proposes to deal with the matter. And I hope you ask me a couple of supplementary questions, Senator Waters, because I look forward to explaining to you why those provisions are too widely drawn and why they are a threat to our economic security.
Thank you, Attorney General. Time for answer. The question's expired. Order. Both sides. On my right. Order. On my right. Senator Waters, supplementary question.
Yes, thanks, Mr President. This is not the first, but it's in fact the second time that the Environment Minister has ignored crucial scientific conservation advices. Both times it's been the community that's had to uphold environmental laws through the court, and won, which you've just called gaming the system.
Order on my right.
When will the government start enforcing its own laws so the community doesn't have to?
The Attorney General.
Senator Waters, what we're going to do is we're going to have laws that work properly, that respect the interests of all relevant stakeholders. Now, the provision of the EPBC Act, which I had particularly in mind, Senator Waters, section 487(2), gives standing to anybody who answers this description. An individual who is an Australian citizen or an ordinary resident in Australia who at any time in the 2 years immediately before the relevant decision has engaged in a series of activities in Australia or an external territory for protection or conservation of or research into the environment.
Order. Senator Waters, a point of order.
Yes, President, a point of order on relevance. The Attorney's demonstrating he can read, but he's not actually answering the question, which went to when the government will start enforcing and upholding its own laws.
Well, I think, Senator Waters, at the very commencement of the Attorney-General's answer, he went to the nub of your question in relation to the reformation of the law. But I'll listen intently to the rest of the answer. Attorney-General.
So, Senator Waters, the provision, subsection 2, is so widely drawn that anyone, regardless of whether they have a material or relevant interest in a project, has a capacity to approach the court to seek an order to stop it. And that's why I use the term vigilante litigation, Senator, because certain radical
Thank you,
environmental
Attorney
activists—
General. The time for answering the question has expired. Senator Waters, final supplementary
Yes,
question.
thanks, President. The community already faces huge barriers in trying to enforce the law when it's ignored, either by vested interests or lax governments. So, as you would well know, only the most meritorious cases ever make it to court. The barriers include legal fees, strikeout orders for vexatious claims, huge potential cost orders and very restrictive grounds for review. And yet you want to go further. Are you the first ever Attorney-General who wants less law enforcement?
Attorney General.
Well, let me say, Senator Waters, I'm not the first Attorney-General who wants law reform. And when we see a provision in an act of this parliament that is so poorly drawn, so widely drawn, that it actually encourages opportunist and vigilante litigation, then we ought to get rid of it. That's not just my view, Senator Waters. This is what Dr Lynham, the Queensland Labor Mines Minister, said. We're extremely disappointed there's been delays to Adani and the Galilee Basin. You have to realise this is a federal issue, and we've asked the federal government to sort it out as soon as possible. Well, we are sorting it out, Senator Waters, and we're expecting Dr Lynham's political colleagues here in the Senate, from the Australian Labor Party in the Senate, to support us in doing the very thing that the Queensland Mines Minister has asked the federal government to do, to sort it out so that this provision does not constitute a permanent blockage to the capacity to develop the great coal mines of Queensland.